Hello, everybody. Good afternoon. How's everyone doing today? All right. My name is Ike Nwankwo. I am one of the class marshals for 2025. On, thank you. Appreciate it. Uh, there you go. All right. Go section 5. On behalf of the class marshals, we are very grateful to have Professor Charles here today as part of the opening of our last lecture series. The last lecture series is an opportunity for professors to give us some guidance and final words of wisdom to the graduating class. And so for those of you guys that are here today, just be reminded that this lecture will be recorded, and it seems like you guys have all gotten food. So with no further ado, I will introduce today's speaker. So it's my distinct pleasure and a true honor to introduce our speaker for today's last lecture, a beacon of legal scholarship and a transformative figure in the realm of law and justice, Professor Guy-Uriel Charles. Please give him a round of applause. Thank you. Professor Charles has carved an extraordinary path in the legal field, marked by both distinguished scholarship and profound contributions to our understanding of law and society. He currently holds the prestigious position of Charles J. Ogletree Professor of Law at Harvard Law School, where he leads as the faculty director of the Charles Hamilton Houston Institute for Race and Justice. His work delves deeply into how law mediates political power and addresses racial subordination, illuminating crucial aspects of our legal system and its impact on society. His academic journey began with a Juris Doctorate from the University of Michigan in 1996, where he displayed early promise by founding and serving as the first editor-in-chief of the Michigan Journal of Race and Law. Following his graduation, he clerked for the esteemed Judge Damon J. Keith of the United States Court of Appeals for the Sixth Circuit. Professor Charles' passion for legal education and scholarship then led him to serve on the faculty at the University of Minnesota Law, where he held the Russell M. and Elizabeth M. Bennett Professorship and was awarded the Distinguished Teaching Award. Professor Charles' journey continued at Duke University School of Law, where he not only taught, but also held the Edward and Ellen Schwarzman Professorship and received another distinguished teaching award. His tenure at Duke further established him as a leading voice in election law, constitutional law, and critical race theory. Beyond his impressive teaching career, Professor Charles' influence extends to the national stage. In 2021, he was appointed by President Joseph Biden to the Presidential Commission on the Supreme Court of the United States, a testament to his expertise and thoughtful leadership. He is also a member of the American Academy of Arts and Sciences and the American Law Institute, further underscoring his outstanding contributions to the field. Professor Charles is a prolific author and editor with works that challenge and inspire, including his co-authored textbook, Election Law in the American Political System, and his insightful public writings and publications such as the New York Times and the Atlantic. Today, we are privileged to gain insight from a scholar whose dedication to justice, equity, and the transformative power of the law continues to guide and shape generations of legal minds. Please welcome me in please join me in welcoming Professor Guy-Uriel Charles.
Thank you so much, Guy. Oh, sorry, you already have it. So grateful to Ike and to all of you. Ike and I share a number of things in common. We were both stars on the basketball court where he was lobbing the ball to me as I dunked it with ferocity. Of course, you don't believe that, though you would believe. Ike's amazing and profound career prior to coming here to law school. I am profoundly grateful to all of you and to my former Section 5 students, but to all of you for choosing me to be one of your last professors that you will hear from as you complete your time here at HLS. There really is no greater privilege than being a teacher, your interlocutor, your cheerleader, and yes, also your student, because I've learned a lot from you. And I take that responsibility, that of teaching, with the utmost seriousness, and also in this moment, with a fair amount of trepidation, if I should be so honest. When I agreed and felt the honor of being selected, and then as time went on, realized where we found ourselves, I guess it became too late to back out. So I realized that I would be speaking probably at a time in which there are going to be so many, and there are so many questions about us as lawyers and about the legal profession. And I wanted to think about something different to address, but it would be both short-sighted and cowardly of me to pretend that this is business as usual, and to attempt to insult your intelligence. And as I like to remind you all, you got a 15 billion on the LSATs, and so there are few people in the world who are as perceptive, intelligent, but also as thoughtful as the lot of you. So I've been asked to address you precisely in a time in which our society and legal system seem to be rethinking commitments that once seemed bedrock and foundational. And no matter how one feels about the current moment in which we find ourselves as a society, there is no doubt that it is different, that it is momentous. From my perspective, Benjamin Witt of Lawfare accurately captured and captures the current mood in a recent article as he describes it. People feel instinctively that the moment is portentous. Some find that portentousness exciting. Some find it menacing. But it clearly isn't business as usual. It clearly matters. If I may paraphrase Witt, whether you agree or disagree with where we are and where we are headed, it is and should be clear to all that we are embarking on a course that is very different from the one that we were on. That we are rethinking fundamental lines that at least we had appeared to be committed to, what was public and what was private, what was state, what was market, what was embedded in notions of separation of powers or checks and balances, fundamental precepts and principles. I do want to focus, however, on one aspect of what Witt calls the situation, that I think is relevant to my task for today. And I'm guessing that for some of you, the issues raised by the current moment directly, or the situation, directly implicate not just the legal profession, but also legal academic teaching as well. And I'm guessing that for some of you feel this way, the challenges of the moment, you may be asking yourselves whether there's anything of value to the teaching that we have imparted to you over the last 3 years. I also recognize, as Witt's put it, that for some people this is more of an opportunity or a course correction, right? That not all share the fear of where we are headed. So perhaps for some, there was not much value in what we were teaching, and that for some of you, you may be looking forward to a different world with a different type of orthodoxy. So I want to take my task this afternoon to address the full range of views and to be able to speak to those who think that this is a marked departure from fundamental commitments and are fearful, and to those who think this is a marked departure from fundamental commitments and are hopeful. You are mere weeks from graduating. You are closer to being my peer than my student. So I'm not going to tell you how to think about the current moment, nor am I going to offer solutions or prescriptions. But what I want to do is just share with you how I'm processing where we are and what it is that undergirds that processing. And as a point of departure, I just want to provide the 3 guideposts to which I will return. These are just my own guideposts as I'm thinking through this. First, to borrow from the actor Mandy Patinkin, the wheel turns. I'll come to that to explain what that means in a moment. Second, we need to be committed to each other's humanity, and I'll talk about that at the end. And then the third, I'll borrow this from the Black experience, particularly from the Black church experience. Weeping may endure for a night, but joy comes in the morning. Okay, but first a bit of biography, just to situate why I think about all of this the way that I do. You might intuit from the name, if you don't know it already, Guy-Uriel Charles. I come from a family of immigrants. Both of my parents emigrated from Haiti to the United States. I was raised in the US, but born in Haiti. I'm the eldest of 4 and the eldest grandchild on my mother's side. My mother has 6 siblings, all sisters. And as the eldest of 4 and the eldest grandchild, and my cousins and siblings will say this, and we will all admit it, was spoiled. It is true. Probably the favorite. I must confess, it's true. But chock full with expectations, and I will address why that's relevant in a moment. My mother was the first to emigrate. My father followed a year later. My brother and I, the 2 of us were born in the States, 2 of us were born in Haiti. My brother and I stayed with my mom's parents and my mother's sisters. So at approximately, when I was about 6 or so, 5 or 6 or so, and my brother 3 or 4, I don't know exactly how old we were, but my parents left us. So sort of imagine leaving your kids. And I didn't fully appreciate this until I had kids many years later and looking at their ages and thinking about leaving them I love my siblings. They are amazing and great people. But I couldn't fathom the thought of leaving my kids to them for a world unknown. And knowing how much my mother and father care about us, I wanted to think about what is it that compelled them to see this as the option that was available to them. We joined them 2 or 3 years later. My parents worked and have worked, they are now retired, working class jobs. First as live-in workers, then as factory workers, and my dad also, they both worked in the same factory, but he also pastored a church. They had various part-time jobs, including cleaning office buildings, and my brother and I would sometimes accompany them and work alongside them. So this is one of the reasons why I have a special affinity, by the way, for the folks who clean our buildings. They remind me of my family, of my mother's sisters, of my dad's brothers, and of my parents. I was the first to go to college and law school and then graduate school. And growing up in an immigrant community, I was surrounded by smart, ambitious people, my mother included. She went on to get her GED and remarked often about the inability to pursue her education to the fullest, and she didn't do so until well after her 60s. But in the meantime, and prior to that, she lost her finger in an industrial accident, or part of her finger, in the factory where she worked. Sometimes, those of you who remember this from civil procedure, I would talk about one of the cases in which a worker would loses their finger, and for weird reasons, I always found it humorous as opposed to difficult, but it did remind me of that story. So I was surrounded by people who fled their homeland, but I was surrounded by people who fled their homeland because the institutions in which they grew up really did not work and did not work well for them. And that was foundational for me. Part of the reason why I became a lawyer, part of the reason why was there weren't a ton of choices in my family. But one reason is because I wanted to understand why certain set of institutions worked and why a certain set of institutions did not work. I am an institutionalist as I care about institutions. I care about them working, and I care about them working for every part of the society, because I grew up with the costs of a group of people for whom they didn't work. And I also recognize that the opportunities that I had, especially as a Black person, as a Black young man growing up in a very different society, was as a function of the fact that a lot of people, especially African Americans, gave up a lot to create legal institutions and other types of institutions that were much more inclusive, to open up the constitutional order so that it could include a bunch of people for whom it wasn't intended to include. I went to law school, some of you have heard a little bit of this, to be a civil rights lawyer, but really without a full sense of what that meant. I recognized that those were the people who helped build a more inclusive legal order, but didn't fully appreciate what it is, in fact, that they did. I learned there and prior, but it became much more evident there, how imperfect the constitutional order was. Now, I had personal experiences of it as imperfect. In my younger days, I have been called the N-word more times than I care to count. I was a summer associate at a law firm. It was actually amazing. I think we had just come from a summer outing at the firm, and I was riding in a car with a Black senior associate coming back from this outing when we were stopped at gunpoint by the police because they were looking for a stolen car. It's the only time that I've been stopped at gunpoint, lots of guns drawn, but not the only time that I'd been stopped. In fact, my co-author and I, when we were in graduate school in particular, we would joke he is a light-skinned Puerto Rican man. We'd drive in my car. Relatively, we're graduate students, relatively not the kind of cars that you all drive. That's a dig, by the way. It's supposed to be funny. We were driving in a beat-up car, and we would joke, like, how long would it take for us to get stopped? And he would joke about the peril of driving with me, and I swear this is true. We're driving with his siblings one time, and not even in Ann Arbor where we went to school, and he said to them something to the effect of siblings and cousins, a brother and a cousin, something to the effect of, hey, when you ride in a car with me, we are prone to get stopped. And sure enough, we did. It happened. We got stopped. So as a younger person, I won't venture to think about how many times I've been stopped or racism experienced throughout various aspects of life and career. So it is by no means a perfect legal order, right? That is, one can think about this systematically, but also one can personalize it. It is, in fact, flawed. And so sometimes one wonders, well, what's the point? And so here I want to detour from the lessons that I want to draw in a moment to tell you the story, one of my favorite stories that I've told it once before in a lecture, and I want to share it with you now, of Louise Lasseter. I'm not going to take too long to do it, and this is coming from the book project that Louise and I are working on. Louise Lasseter was a resident of Seaboard in Northampton County in North Carolina, and she just wanted to register to vote in 1956. And she went to the place where she was supposed to register, which turned out to be the general store. She met all the formal requirements of registration. She was 41 years of age. She was old enough. She lived in the county. She wasn't a person convicted of a crime which would have automatically excluded her from registering. She was not illiterate, though she only had completed 1 year of high school. So if this were a function of simply a matter of meeting the legal requirements for registration, her experience should have been pretty straightforward, and her name probably would have been unknown to constitutional history. But she was a black woman who lived in the rural South in the 1950s, in an area with a substantial black population, but before the passage of the Voting Rights Act of 1965. And in a moment in which the state had effectively disenfranchised almost all of its black citizens, though there were more black citizens registered to vote in the mid-50s in North Carolina than at the beginning of the 20th century. Most of the state's black citizens couldn't vote. And things were worse in the rural counties where Louise Lasseter was born and lived all of her life. Part of what I find interesting about that story is that here is a woman with barely a high school education, really taking on an oppressive and difficult legal system. And while some things had changed, much had not, and she had a lot to lose. She knew the challenges that were ahead of her. And part of what's further interesting about the story is the dehumanization that she experienced. So in addition to requiring voters to be literate in order to vote, North Carolina law purported to excuse the lineal descendants of those who were entitled to vote in 1867 from being subjected to the literacy requirement. So here she was, having lived in this place all of her life. She's going to be subjected, and she knew she was going to be subjected to a dehumanizing experience. She also knew that she had a lot at risk given her material precarity. So she wasn't simply attempting to exercise the right to vote. She was also putting at risk her livelihood, that of her family, and in some respects, the challenges that would come to her community. I also find interesting in the story the fact that Louise Lasseter did not prevail, at least not immediately. Her lawyers took her case to the Supreme Court, and they lost. They lost in the courts below. They lost in the Supreme Court. They more than likely knew that the odds against them were fairly high. But nevertheless, they fought, and they fought at great risk to themselves. So one of her lawyers, Samuel Mitchell, died penniless, in part because he dedicated his life to fighting racial discrimination in the South. No one knows recognizes the other lawyer, James Walker, but he was the lawyer who recruited Louise Lasseter as the plaintiff, and who spent also much of his life challenging racial discrimination. He was persecuted for doing so, prosecuted, and briefly jailed for his activism. They are some of the local heroes, but who are not as well known, in some respects not even well known at all, as compared to the Rosa Parks or the Thurgood Marshalls. Here's a woman who is not extremely well educated, but nevertheless took on the system, even though the odds were stacked against her. Part of what I find interesting here in the lesson is that even though they did not prevail in the short term, and even though they faced great odds, they persisted, and eventually the legal and constitutional system caught up with the vision of Louise Lasseter and her lawyers, and the 1965 Voting Rights Act eventually got rid of the literacy test. And here I want to point to the first observation, which is the one from Mandy Patinkin, that the wheel turns. I used to have this, I heard him talk about, say this in an interview, used to have it printed out and printed in my office. And I take two things from that statement, the wheel turns. The first is, notwithstanding the fact that at a moment things might look bleak, right, that Louise Lasseter, 1956, 1950s, it's hard for us to imagine what it is like to be a black person in 1950s rural North Carolina. I know what it was like to be a young black person in the North. We used to joke, my friends and I, when we were young, if we were going somewhere, would tell one another, would say, look, if I'm not back by, make sure you call the NAACP. It was partly a joke and it was partly serious, but nothing resembling what life must have been like in 1950s North Carolina. But the wheel does turn, which means that for those who were at the bottom, eventually justice catches up and the hierarchy fundamentally changes. But there's also the flip side to that lesson, which is that we should also worry, for those of us who are at the top of the hierarchy, how we are treating other people who are at the bottom of the hierarchy, because the wheel turns. And thinking about the turning of the wheel, the lesson that I take is the importance of being committed to creating and supporting the liberal American, and liberal here I don't mean political liberal, the theoretical liberalism, liberal American constitutional republic that is as inclusive as possible. Part of what I think makes our society work is that fundamental core commitment to all and each and every single one of us. And in law, sometimes it is clearly and easily represented. And the place where one can point to it, at least one place that one can point to it, is in Justice O'Connor's Grutter opinion, in which she says, hey, our system can't be legitimate if it isn't open, if everybody doesn't see that it is open to all of them. And by everybody, here, I want to emphasize that everybody means everybody. Right? That is, I think, a commitment to a liberal political order, to one that is inclusive, includes the full range of our society. So it isn't, people take the statement, for example, Black Lives Matter, to mean something exclusive or hierarchical. And I'll come back to this in a moment. No, it is a promise of solidarity to people who are at the bottom of of the order. Right? So whether the person who ends up at the bottom of the order is white males based on their socioeconomic class, whether it is Asian women, whether it is people based on their religion or sexual orientation or their national or place of origin, it is a promise of solidarity, of inclusion across the ideological spectrum, across the racial spectrum, across the regional spectrum, across all salient identities. And to be committed to that inclusion means to be committed to every single part of it. And so part of how I understand my professional career, and my civil procedure students have heard one version of this, is trying to understand or create or support a framework where people with existential differences, where people who find themselves in different part of the wheel can build community with one another, and that community can be as inclusive as possible. And so the commitment to inclusiveness, from my perspective, is core and fundamental and a necessary part of the constitutional order. It helps us to provide a framework for the promotion of human flourishing and individual liberty. It is, for me, an important motivating framework. But of course, this is complicated because we are not all on the same page. And how should we think about the fact that we are not all on the same page and that we have different sets of commitments? So here, I want to articulate a fundamental worry that I have about the current state of American democracy, which is the fact that we are all each retreating within our separate identities into our various corners, and from there, thinking that we are better and safer within those enclaves. And my worry is that that is inconsistent with not just inconsistent with building an inclusive political order, but that it cannot last. That we will either learn to live together and figure out how to do so, or we will die apart. That it is important and necessary to recognize each other's humanity, especially and particularly where we disagree with one another. One of the lessons that I've learned from growing up in a community of difference, and part of what was interesting about growing up in Stamford, Connecticut, was, at least at the time, I don't know what it is like now, is that difference, you saw difference almost everywhere that you went. So you had all sorts of different types of communities. You had the Italian community center, the Irish community center, the Jewish community center. You had various types of black communities, where there were African Americans who were brought over from Africa as part of the slave trade, or recent immigrants from Jamaica or Haiti, had different types of Latino and, to some extent as well, Asian communities. And one of the things that you learn fairly on was, what is it that enabled us to have commonality, and then where is it that our differences enable us to create our uniqueness and individuality. And part of what was fascinating about that framework is to be able to hold on to difference while at the same time figuring out and building solidarity and commonality. It wasn't easy, but it is a lesson that I learned. And you also try to understand what it means to be vulnerable when you are alone. So now we're in the midst of thinking about ICE raids. But I remember the versions when I was a kid, the versions in the 80s and early 80s or mid 80s, if my recollection serves me right, where there were raids by then the Immigration and Naturalization Service. And people in immigrant communities were so fearful, and they would call one another. And the impression that that made on you on how vulnerable people were, even though you were living in mixed status communities and you didn't feel that vulnerability, but everybody around you felt that vulnerability. And the question was, how do we build solidarity within a context in which different groups and communities are essentially being pit against one another? I've learned early on, even in law school, that that we have more in common in many respects with one another than we might think, because it is easy to look inward and think that we are special, alone, and unique. But part of what it means to build a constitutional framework is to build bridges across difference, is to build relationships outside of our basic groups, is to recognize one another's humanity. And so one of the my guiding principles is, how do I maintain that commitment to, yes, understanding the framework and perspective that I am coming from, but also to recognize a different perspective and others, particularly where we don't share the same epistemic framework. Right? How to build a system where people can act in solidarity, where they can be good to one another, where they can be wary of self-righteousness. All right, and then the very last point. And here, this is the lesson from Black culture and tradition. So I do think often of stories like Louise Lasseter, right? And what it means to have lost, at least for a time being. In her case, it was at least 9 years, almost 10, right? Without getting a fundamental change in the legal system and the legal framework. And really, if you want to think about it, it was much more than that, right? Because when you're thinking about the American framework in 1965, and even in 1970, and even 1980, it was still rife with evident discrimination and racism. So what is the lesson for thinking about today, and what is the approach that I have? Well, the thought and the theme that comes to mind is something that one learns from Black culture and tradition, that weeping may endure for a night, but that joy comes in the morning. And so I want to think about the various aspects of what that means, at least for me. So for me, it means that, look, there will be weeping. That is a reality of one's existence. Structural inequality is real, and the type of things that pit us against one another is also real. That we have various communities, and here I want to be as inclusive as possible, that are experiencing a type of disillusionment and fear. I think we ought to recognize that. We ought to recognize that there are challenges that come with this moment. There will be weeping. Weeping endures. But it endures for a time. All right, in this case, the time frame is a night, but it sort of represents the time period. But joy does come. Now, I don't think joy comes simply because it is inevitable. I think joy comes also partly because people are committed to the basic of the common framework, to building a framework and a system that reflects the type of humanity and solidarity that befits a free people. I think joy comes when folks are committed to one another and understand and try to understand, notwithstanding their fundamental disagreements, how somebody could see something from the other side and acknowledge, at the very least, the pain that somebody else is feeling, even though that is not the way that you see it. For me, growing up as the eldest of four and a family of immigrants and the eldest of the cousins, part of what you were expected to do, at least I was expected to do, was to figure out how to hold things together, how to bridge things together, how to be part of those who help to bring a different reality. One of the things that I've learned from you all and from this community is that you are insistent on bringing joy. Weeping will come. Joy is a function of your insistence. Joy is a function of your solidarity. Joy is a function of how well you want to see and appreciate that even though this is not your reality, that you can put yourself in the place of somebody else and try to understand their reality, find commonality, and build a framework that works for all. So even though weeping is promised, joy in part is what you can deliver. Part of what I've learned from all of you, where I've gone from teacher to student, is the challenge of how myself to be committed to changing the legal order and to be as well an agent of joy. The challenge of rethinking the framework to make it as inclusive as possible. And so this afternoon, I don't have any prescriptions for you. I don't have any solutions. And if I purported to have them, you shouldn't believe them. And for those of you who were in my first year classes, I don't even have drawings. I apologize for that, for depriving you of what I know is the highlight of your education here at HLS. And for those of you who fate did not place into one of my classes, or your better wisdom has precluded you from taking them, you should also understand that no, I am not a great artist. I just like to play at being one. But what I think I can offer are, at least for me, my three guideposts. Which is, the wheel does turn. It does eventually. And we should both be hopeful and worried. That we ought to be committed to community and solidarity and understanding one another. And though even in the darkest moment, where it seems that hope might be lost, and you wonder why it is that you've spent the time and the money, think of Louise Lassiter. Think of her lawyers. Think of the difference that they've made, even though it might have taken 10, 20, 30, 40 years. And even if for you this is a hopeful moment because this is much more consistent with your preferred order, how do we build community and solidarity together? Because weeping will come for everybody, but joy is a function of choice and a function of solidarity. Thank you for the time.